Perfect. Awesome. Okay. So, for any of you who are here watching on Facebook or on our Zoom webinar, I have the privilege to introduce you to somebody in my life who's really helped me through some hard times, Jack Heisler, estate attorney extraordinaire, along with a CPA, which I actually just realized not too long ago. And what's a interesting story is, and this is the situation you never really ever want to be in, is about 18 years ago, I would take my dad to dinner every Wednesday night. And one day my dad, using the little German word for sweetheart, would say, Schatzi, he said, I want to show you where the important papers are. My dad was an older dad. He had me late in life. And I kind of said, Daddy, stop it. And, but he enforced it, and he was like, they're right here. They're right here. And I was 28. I was like, okay, fine. The weird thing is, about a week later, he had a pretty big stroke. And I needed those papers. And those papers are the papers that we're going to talk about today. And it turns out that the estate attorney that handled my dad's estate, subsequent after he passed away, was the esteemed our guest Jack Heisler, who, in my opinion, doesn't get paid enough, and he handles an incredible, difficult time. I know that we as real estate agents handle a very difficult time, but the amount of grief and pain that you work through is just huge. And you were really instrumental in helping me get through that terrible time. And then it turned out that I moved into the same neighborhood as Jack. So we get to see each other almost at least a few times a week when we're walking through the neighborhood. So Jack, thank you for joining me today and talking about this really important topic. I really appreciate it.
Thank you. I remember when you called me to give me your new address, I said, wait, you're my neighbor now.
I know, it's crazy.
I appreciate you having me on.
Good. Well, I'm glad.
It felt good to put on a dress shirt today.
Exactly. I know. I was like, I got a jacket on.
Yeah. Well.
So we are here on Zoom. If you do have questions, Jack normally does this presentation in person. So if you have any questions, you are free to ask in the comment section on Facebook or here on the Q&A on the website. So whatever works for you, you are free to. We do have a PowerPoint we're going to run. But I'm gonna let it go. Jack, if you want me to, do you want me to go ahead and load up the presentation?
You can start with the first page.
Great. All right, I will. So let's share our screen. And there you go.
All right, thank you. So you can skip to the next page. That's my information.
Yes, and if you need or want to call Jack, he's very available. So, all right.
Skip on. So estate planning, what is estate planning? I think that the best definition I've ever seen in my 35 years is estate planning allows you to develop a plan that allows you to give what you own to who you want to receive it, when and how you want them to receive it, at the least possible cost and delay. When we talk about costs, we're talking about taxes. We want to avoid taxes. And we want to avoid attorney's fees. Next page, please. So estate planning isn't just about planning for your death, though. In fact, 2 of the 3 documents I'm going to talk about today are to plan for your own possible disability. And only the last will and testament deals with your death. Next page, please. So the last will and testament. Will and testament actually mean the same thing. And I've been told that it's called a last will and testament because back in the old days, 1,000 years ago or so, lawyers got paid by the word. So they used 2 words instead of 1 and got paid more for creating that document.
Are you serious?
That's my lawyer joke, but it's a true story, though.
That's hilarious.
So to make a will, you have to be 18 years of age, and you have to be legally competent. Now, legally competent is a pretty loose term as far as determining whether you're legally competent to create a will. You really just need to be aware of your assets. You need to be aware of the fact that you're creating a will. You need to be aware of who the people are that you've named in your will. And you have to also know who the, quote, objects of your bounty, unquote, are. That means if you are of the delusion that you don't have children when you actually do, you're not competent.
Oh.
A will has to be in writing, has to be signed by the testator. The testator is the person who creates the will. If it's a man, if it's a woman, it's a testatrix. And it has to be witnessed by 2 witnesses, and everybody has to be in the same room, see each other sign. Just recently, Governor Hogan came out with an executive order that does allow now for remote witnessing of wills and powers of attorney. So people now, during this crisis, can execute wills remotely. They'll do it like we're seeing each other on the screen right now, where they can, on screen, see each other sign the document. Next page, please. Once you have a will, how do you revoke it if you want to revoke it? Next, please. Oh, skipping the revoking of the will. The revoking of the will, there's a couple of ways to do it. That's okay. To revoke a will, you have to execute a new will. Every will that we have says, the first paragraph says, I hereby revoke any and all prior wills or codicils created by me. You also you can revoke a will by destroying it, so you can tear it up, shred it, cross through it. You revoke a will, if you have a will and you get married and have a child, your will is revoked by law. And if you have a will and you get divorced, your will is revoked, but only the parts of your will that pertain to your spouse. So some of the common mistakes that people make about estate planning and not having a will. The first mistake is assuming that the law will make a distribution of your assets the way you'd want them to be distributed. So if you die without a will, that means you've died intestate. It's called intestate. If you're married and you have a minor child, your children receive half of your estate and your spouse receives the other half. If you're married and you have grown children, your spouse receives the first $40,000 of your assets, and your children, and then your spouse receives half of the balance, and your children receive half the balance.
That's if you're intestate, meaning you don't have a will.
This is all if you're intestate without a will.
Okay.
If you're married, but you're married for less than 5 years, your spouse receives the first $40,000 of your estate, and then half of your estate, and your parents receive the other half of your estate. So in 35 years, I've never had anybody write a will that said any of those 3 things. So it's not true that the law will distribute your estate the way you would necessarily want it. Next mistake that people generally make is not understanding which assets pass through your will. So assets that your will distributes are only those assets that are in just your name. They don't have a beneficiary. They don't have a joint owner. So assets like retirement accounts, they have beneficiary forms. Beneficiary forms override anything that your will said.
Interesting point. So that overrides anything. So like if you wanted to revoke or change your will, like we talked about just a minute ago, but yet you have accounts with beneficiary forms, they would override.
The beneficiary forms override what the will says.
Very interesting.
Absolutely. And a lot of people don't understand that. So
Right.
They think if they change their will, they've changed the beneficiary on their account.
That's interesting.
Annuities and life insurance policies are the same way. They have beneficiary designations. So the beneficiary forms control where those assets go. Jointly owned accounts obviously pass to the joint owner. So you can't distribute any jointly owned assets in your will. If you have assets like bank accounts with a POD or a TOD designation, POD standing for pay on death, TOD is transfer on death, those beneficiary designations overrule what the will says.
Oh.
And assets that are owned by trust. So a lot of people create a revocable living trust to avoid probate. So if you put your assets in a trust, then your will does not distribute those assets. Another mistake people make is not planning to reduce or eliminate taxes when they die. Now, the estate tax right now is not a problem for most people. The federal estate tax exclusion amount right now is $11,580,000 per person. That's per person. So a married couple has a $23 million plus estate tax exclusion. The Maryland estate tax is $5 million per person. But there is a local inheritance tax of 10% if you leave your estate to nieces, nephews, cousins, friends. People aren't aware of that local inheritance tax of 10%.
Is that if the receiver is in Maryland? So like if my uncle in Ohio left me money, is that the 10%? Or if I leave my what if my niece is in Georgia and
Maryland controls the inheritance tax if it's your estate. So your uncle in Ohio who left you money, I'd have to say it depends on what their law is about inheritance tax.
okay.
But if you're in Maryland leaving money to your niece in Ohio,
Mhm.
she's going to pay a 10% inheritance tax.
That's what I was asking. Okay. And I do have a question about the trust. You mentioned a trust. Can we talk a little bit about that, or where can we talk about the trust?
We could talk about the trust right now. So people create a revocable living trust to avoid the probate process. The probate process is having the will submitted to the local register of wills or orphans court for approval and supervision. So there's fees involved, and there's a lot of paperwork involved, which usually involves hiring an attorney to do that. And there's a delay. And finally, there's a matter of it all being of public record. So if anybody has a will that's probated in the Register of Wills office, anybody can go into the office and read the will. They can see what you owned when you died. They can see what you owed when you died if you had debts. And they can see who's going to receive your estate, right down to name, address, so they can go after the people that are receiving assets. All that can be avoided by a trust, a living trust, where you transfer your assets to the trust. The trust owns the assets, you don't. Although you can be your own trustee, you don't lose any control with a living trust. And then when you die, the trust can be distributed literally the day after you die. You don't have to go through the court for anything. There's no.
Can you put all of your assets into the trust?
You should. The idea would be to put all of your assets into the trust, except you don't put retirement accounts into the trust, but all other assets should be placed into the trust to avoid probate.
Interesting.
Okay. One other thing on taxes, there is, we talked about the retirement accounts and the annuities, savings bonds. Those assets have never been taxed during your lifetime, and so they have to be taxed when you die. So if you have a person with an estate tax, with a federal estate tax, a Maryland estate tax, then you have to pay the federal income tax and Maryland income tax on a retirement plan. The beneficiaries literally could end up with pennies on the dollar. So if I have a client who's charitably inclined, I tell them to leave the charities the retirement monies, because the retirement monies won't be taxed if they go to a charity. If they're going to an individual beneficiary, they're going to be taxed. Okay.
Mm-hmm.
Next page, please. So what should you have in your will? A lot of people like to spell out their funeral arrangements. If they want to be cremated, or if they want to be buried with someone or somewhere in particular. I've had a number of clients provide for a celebration, a life celebration, so they want to have a big party when they die. That all should be in the will. Specific gifts. So if you have a husband and wife, my experience has been that the mom wants to leave her jewelry to her daughter or to her daughters. So that would be a specific gift. It's not just divided equally between all the children, going specifically to one person. If you have children, minor children, or a disabled child, or a beneficiary who I call fiscally irresponsible, not very good with money, you want to set up a trust for those people in your will. You also want to have what I call the ultimate distribution. So that is distribution to people if the whole family predeceases. So in other words, there's a common accident. And when I sit down and talk to clients about that, I say, well, suppose that you and your wife and all your children are killed in a car accident. Where would your money go? And they look at me and they say, man, you're really weird. Why would you ask that? But we know it happens. And if you leave it blank, then it's going to be an ugly result, like what we talked about before, where the assets go to people that you don't necessarily want them to go to.
Yeah, that's a hard conversation.
It's not something that they have an answer to right away, I can tell you that.
Oh, I bet. Do a lot of people pick charities and things like that here, or?
That's exactly what a lot of people do. They say, well, if we're all gone, we'd like to help out some of our favorite charities. So that's a good idea, that people resort to charities when they get to that point in their will. Your will should name your personal representative. That's the person who files your will with the Register of Wills, pays all your bills, collects all your assets, pays your taxes, and distributes your assets the way the will says. If you have a trust in your will, you need to appoint a trustee. And if you have minor children, you need to appoint guardians for the minor children.
We do have a question from Facebook. Do you recommend naming the trust or individual as a beneficiary on retirement accounts?
Individuals work better, although trusts can be a good beneficiary if there's a need for trust protection. But tax-wise, individuals are probably a better way to go.
Okay.
But if you need the trust protection, then the sacrifice of having a trustee as a beneficiary of a retirement account that sacrifice isn't as much as the trust protection that you're receiving.
Okay, thank you.
So the guardian for minor children is a decision that usually holds people up from making a decision. It's a very hard decision to make. Who are the children going to live with? And that is something that people usually have to take some time to go back and forth and find out who the best candidates are. For the personal representative, for the trustee, for the guardians, I always recommend that you have your first choice and your second choice, maybe even a third choice. The deeper you go, the better.
Really?
Because if you name somebody and they're not around,
that far.
If you name somebody and they're not around, then you might as well have not named anybody. So you have your first choice, your second choice, and your third choice if you can.
Okay.
All right. Next page.
Next.
Oh, we're on to the durable power of attorney. So the power of attorney in Maryland changed in 2010. We had a statute enacted in October 2010, the Maryland General and Limited Power of Attorney Act. The power of attorney is designed to avoid a court-appointed guardianship. If you don't have a power of attorney and you become disabled, somebody's going to have to petition the circuit court in the county where you live to be appointed as your guardian. And to do that, they're going to need to hire a lawyer. The first thing the court does when they get a petition for guardianship is the court appoints a lawyer for the person who's allegedly disabled. Because the court doesn't know that you're disabled, they have to have somebody investigate. And you got 2 lawyers on the clock. Not a good thing. The guardianship is all a matter of public record. It's an open court. Once you get appointed as guardian, you have to account to the penny for everything you spend for the person who's disabled forever, or as long as the guardianship exists. All that can be avoided by having a properly drawn up power of attorney. Prior to the Maryland Power of Attorney Act that came in 2010, everybody had their own power of attorney form. I had my own form. The lawyer upstairs, she had her own form. The bank had its own form. The investment company had its own form. So it was a mess, and a lot of the banks would not accept the individual attorney's powers of attorney forms. They didn't feel comfortable accepting all these different forms. So a lot of times, even though you had a power of attorney from somebody, you couldn't get anything done. So the Maryland Act developed two power of attorney forms, statutory forms. And the Act says that if you use the statutory form, then nobody can ask for another form of power of attorney. So you need to be compliant and have your power of attorney be exactly or as close to the statutory form as possible. But the Act says that nobody can ask for a different form. And if there is some pushback from a bank, the Act also says that you can get a court order requiring that bank to accept that power of attorney. And the court order would also reimburse you for your legal fees and court costs. That's a lot of power that's behind the new Act.
So I have one question, because when I was talking about interviewing you, I had someone who lives in Washington State ask me about some state-specific stuff. So this particular conversation is obviously state-specific. Do you know if any other states also, just because I'm nationally connected, like I've got people from Long Beach, California watching. I've got a couple people watching from a variety of places. Do you know if other states enacted a similar thing where it's
Yes.
a unified form?
Yes, they did.
Okay.
It's really the uniform part of the Uniform Power of Attorney Act.
Okay.
And a lot of other states have enacted this. And if you look at the other states' statutory form powers of attorney, the language, for the most part, at least my experience, has been very similar. It's not identical, but it's very similar.
Okay.
So that's the first thing. If you live in a state outside of Maryland, you need to investigate whether your state has a power of attorney act.
Okay, that's very good to know. And you said here in Maryland, it happened in 2010.
October 2010.
Gotcha.
So if you have a power of attorney that was drawn up before October 2010, it's not that it's invalid, but you're just not going to get anywhere with it. It's going to be an uphill battle to try to use that form. Okay.
And you should just update it to use the standardized form.
Yes.
Perfect. All right, good. Okay.
Next, please.
Next.
So the people, the two parties in a power of attorney are the principal. That's the person who grants the authority to the agent, and the agent. I'll be using that terminology for the rest of this section. Now, a lot of people have heard the term durable power of attorney, and what that means is that the power of attorney continues to be valid even though the principal has become incapacitated. The old common law said that if you have a power of attorney and the principal becomes mentally incapacitated, the power of attorney is no longer any good. And that's the whole reason why people have powers of attorney these days. They want them so that they are good when they become disabled. So the documents used to have to say, this power of attorney shall be a durable power of attorney. Shall remain effective even though the principal has become disabled. You don't have to say that anymore. The Maryland law says all powers of attorney are durable powers of attorney unless otherwise stated. The law says the powers of attorney are effective immediately unless otherwise stated in the document. So as soon as you sign a power of attorney, it's good. Your agent can start acting for you.
You know, it's funny, and I know that obviously this was 2002 when my dad had his stroke. Interesting little side note, and then we have one question from the Facebook audience. But so my dad, his eyesight was going downhill. I don't know if you remember this or not, because it was a long time ago, and he was still driving, and it was killing me. And I was like, I was gonna have to figure out a way to get him to stop driving. And then he has the stroke, and it turns out I had power of attorney the whole time. I just didn't know it.
You have a power of attorney, but the power of attorney is, you still have to fight an uphill battle to get your father to stop driving his car. Power of attorney or not.
Nature took a course. So here's the question we have from the audience. We have, is there a basic will you can get from Maryland if there are no major accounts to disperse? No minor children, no house, just a car and a bank account.
There is, from Maryland, there's no place to get the will form other than one of those vendors that legal Zoom or whatever they're called, that sell these will forms that are basically for any and all of the 50 states. The power of attorney form can be found online, and the medical advanced directive can be found online. But there's no place to find a Maryland will form online other than one of those private vendors.
Gotcha. Okay. So I should move on, right?
Yes.
Okay.
Power of attorney has to be signed by the principal. It has to be witnessed by 2 people. You can go back.
Okay.
It has to be witnessed by 2 people, and it has to be notarized. The notary can be one of the witnesses. And again, we do have, pursuant to executive order from Governor Hogan, the remote execution of powers of attorney that are available now, so that it can be done remotely, so that all the 3 people don't have to be together.
Now, that's part of the COVID executive orders?
Yes.
Okay, perfect.
It's only good as long as we're under this emergency.
State of emergency?
State of emergency, right.
That's still good to know, though, because that's still there. The state of emergency is still there.
Still there, yes it is. So a power of attorney terminates when the principal dies, and a lot of people don't know that. I've had so many people when their parent has died tell me they're still signing checks under the power of attorney. They're still going to the bank, and they really shouldn't be doing that. And if the bank found out that their parent had died, the bank would freeze the account. So the power of attorney terminates when the principal dies. Also, as I said, would terminate when the principal became incapacitated if it's not a durable power of attorney. The principal can revoke the power of attorney. The power of attorney can say in the form, there's a blank that you can fill in the date of termination. I never use that, but you can set a date definite for when the power of attorney terminates. A power of attorney for a particular purpose terminates when that purpose is accomplished. So if you
and that's something in the real estate world that many times it is a specific power of attorney to transfer property. So just like this says, when the purpose is accomplished, so when the house has transferred and the documents have been signed, it's gone.
Correct.
Yeah.
And so the power of attorney also terminates when the principal revokes the agent's authority, or if the agent dies or becomes incapacitated or resigns. And that's why you want to have a backup agent. Just like I said with the will, have a backup person representative, have a backup trustee. On a power of attorney, you want to have a backup agent, 1 or 2. The deeper you go, the better. Next slide, please. This is very similar to what we were just talking about. The agent's authority terminates when the principal revokes it, or when the agent dies or becomes incapacitated, or if the power of attorney terminates. What's interesting is if the power of attorney is between a husband and wife and they file for divorce, the agent's authority is terminated when they file for the divorce or annulment.
Right when they filed.
When they file.
Not the divorce doesn't have to be final, just when they filed.
It says when they file.
Wow.
So these are the criteria for the agent, how an agent needs to act, and it's all a matter of the best interest of the principal. I want to pick note number 7. The law requires an agent under a power of attorney to cooperate with the person who has authority to make healthcare decisions. So that's the healthcare agent. We're going to talk about that next. If you name somebody as your financial agent and somebody else as your healthcare agent, and I've seen this a number of times, you're inviting a great deal of conflict, because the healthcare agent might want to hire someone to come into the house and give mom or dad 24-hour care, which is really the most expensive way of receiving care. And the financial agent, who's the money person, they may say, well, we're better off putting mom and dad in a nursing home, not as expensive. And the two are going to have a battle now. Who wins that battle? So there's a situation where you're inviting all of your family issues to wind up in court. So beware of that. Next slide, please. Oh, the Medical Advanced Directive. That's the third document that I always talk to my clients about. Next. So just like a will, you have to be 18 years of age on the Advanced Directive. You also have to be capable of making an informed decision. Now, the Maryland statute gives a negative definition on informed decision. The statute says, basically, when are you not capable of making an informed decision? So if you're unaware, if you're unable to understand the nature, extent, or probable consequences of the proposed medical treatment, or if you're unable to make a rational evaluation of the burdens, risks, and benefits of the treatment, or if you just can't communicate, so you're unconscious or you, for other reasons, can't communicate, then you're incapable of making an informed decision. Next slide. So the Advanced Directive is really a two-part form. The first part allows you to appoint an agent to make healthcare decisions for you. And that used to be called the medical durable power of attorney. The second part allows you to make your own decisions regarding the use of life-sustaining procedures. That document used to be called a living will. So the Maryland Advanced Directive form, the one I use anyway, allows you to put the two documents together into one form. Next slide, please.
So the question about the, and maybe you'll get into this, I remember, so as I said, after my dad had the stroke, so then I was his representative. What do they call it? Signed by the declarant. That he was the declarant, and I was the.
You were the healthcare agent.
I was the healthcare agent. And I'll tell you, I was, gosh, it was so difficult as the healthcare agent, because, it very clearly stated if he had, reasonable, what did he choose? Like there were like 3 different options where he had a reasonable opportunity for recovery or something like that. And the problem is the doctors are like, well, I don't know. They're like, he could recover or not.
Not a lot of help there.
And I was like, okay, you're not helping me out here. Like I knew, and that's what was really challenging as the agent was that, I knew he did not want to be hooked up to stuff. But, here I had these doctors telling me, well, he might be able to recover. And so I'm like, well, what do I do? So it was hard.
I'm sorry the doctors weren't more helpful.
A hard job.
Yeah. The idea really is when there's no hope, and you don't, if the person, the declarant had said, I do not want any life support used whatsoever, you need to make sure there is no hope, right? And if they're holding out hope for you, then you have a real dilemma.
Yeah.
Your dad doesn't want to be hooked up to tubes and machines.
Yep. Yeah. So anyway.
Right. The interesting thing about an advanced directive is, unlike the will and the power of attorney that have to be in writing, an advanced directive can be oral. You can make a statement to your doctor and to another witness and have that become your advanced directive, and they will enter that directly into your medical chart. With my clients that have a written advanced directive, I always tell them to send a copy of their written advanced directive to their doctor and ask the doctor to make that part of their medical chart as well. far as signing of the advanced directive, one witness,
Oh,
the advanced directive doesn't allow for the healthcare agent to be a witness, and at least one witness has to have no financial interest in the death of the declarant. And that's for obvious reasons. We don't want somebody falsifying a document so that they can get their inheritance clear. Next, please. So just like a will and a power of attorney, you can revoke a advanced directive a number of ways. The more interesting thing about the advanced directive is, just like you can create an oral advanced directive, you can orally revoke it. So you can make a statement and have that statement recorded somewhere, and that revokes your advanced directive. So that's, again, that's different about the medical advanced directive. Next. If you don't have an advanced directive, if you haven't named a healthcare agent, the law has a pecking order of what they call surrogate healthcare agents. And this is the list of the surrogate healthcare agents. So your court-appointed guardian is first, then your spouse, an adult child, a parent, an adult sibling, and last is a catch-all, really. It's a friend or a relative. But if you get down to that person, they have to submit an affidavit that spells out their relationship with you and how they might know what your wishes and desires are with regard to your medical care.
so when I was reading through your documentation and I saw this information, I was like, wow, that's really interesting. And so then, of course, my mind went in a million different directions. And so I'm curious. I mean, it's like, okay, so I'm incapacitated and I'm at the hospital by myself. And so, nobody is around. Do they start calling in order? Like, how do they run through this list?
I don't really know how they run through the list. I mean, they have a procedure. I don't know what it is. I don't think that they would automatically look for a court-appointed guardian. So I think they'd be looking for your spouse first, and then children if there's no spouse. But I don't know if there's nobody around and nobody's come in. I don't know what the medical process is for locating family.
Interesting. Okay. I was like, oh, that's very interesting. So
And these are the people that have the say-so. So if there's nobody around and they can't find anybody and you can't communicate, the doctors are going to use their best judgment. They're going to keep you alive as long as they can. And that's their job. Give you the best treatment that they can.
yeah, that I did not know that.
Now, the problem with those surrogate healthcare agents is the law says if people on the same level don't agree, then nothing's going to get done. That the doctor actually has to take the medical decision to the hospital advisory committee. So if you're relying on the surrogate healthcare agents and you have 3 children and no spouse, those 3 children are all on the same level, and they all have to agree. And my experience is that no 3 children ever all agree on something like that.
No.
So, and another problem is if the patient's not in a hospital or other institution, the doctor can't withhold or withdraw life-sustaining procedures unless all the people on the same level of decision-making all agree. Again, that doesn't happen a lot. People usually differ when it comes to these decisions. Next slide, please. So how do you make the decisions regarding the health care? The agent is required to first look at the wishes of the patient. And so how do you know that? Well, first, you read the document. What did the declarant say in their advanced directive? You also resort to past conversations that you've had with the declarant. What are their religious beliefs? What are their other beliefs? How have they handled medical situations and medical issues in the past? And if the healthcare agent doesn't have any of that to fall back on, then they just they're held to the best interest of the patient criteria. I think that's the last slide, so we're
Yep.
open for.
Well, I have a couple of questions for, so a couple of things. Number one, for someone who doesn't have any of these items, right? What's the investment, both time and financial investment? So if they said, you know what, I want to call Jack, I want to get this set up. How long does it take to put this stuff together? Obviously, there's a lot of questions like you were talking about, like the absolute distribution or something that I don't even remember you asking me that. There's questions and thought that have to go into it. But the question is, how long does it take to put these together, and how much does it cost?
Well, the length of time really depends on the client, and a lot of clients are really good about getting back to me and getting their documents back and getting questions answered and changes made. So the process is we meet, the clients and I meet, and we discuss all of this. And if they have decisions to make, well, we can go forward, then they go home and discuss those issues and get back to me with their decisions. And then I'll prepare the first draft of the documents for them to review. We'll send those documents to them, send them by snail mail with printed documents, or by email, whatever the client prefers. Then the ball's in the client's court, and so the client can get back to me in a week. The client can get back to me in a month. It takes different times for different people. And then we get back together again for a second meeting and go over the documents and the changes that have been made. And if a third meeting is required, we can always have a third meeting as well. So that's the process. I can't tell you what the time limit is because a lot of it is up to the client. Our turnaround can be real quick if need be on my end. And as far as the cost, the cost of everybody's plan is different, and I don't know if it's appropriate to be talking about.
Okay, I didn't know. Can I ask if it's like hundreds or thousands?
It's probably, for a good estate plan, it should be for all three of these documents. It should be more than $1,000, but it should be less than $5,000 if there's nothing really complicated.
And I only ask that just because, some of the first slides and the first things you talked about, avoiding taxes, making sure your money goes where you want it to go. Like, that's why I asked you what the investment was to do it, is because it is an investment. It's an investment in protecting your assets, that's why we named this what we named it. So that's why I ask, just because so people know that it's not just, there's an investment aspect in protecting your.
There is an investment aspect, but I can tell you that the investment that you make in having these documents drawn up is a fraction of the money that will be spent if there are no documents and things end up in court somewhere. That's when the legal fees really build up, when people have to go to court to fight over issues. Should have been decided by the people, the parents, or the person who died, or the person who's disabled.
I'm gonna stop sharing and see if there is anyone watching on Facebook that has any other questions. Jack was just incredibly, I said that at the beginning, and I know that I've got some new viewers now watching, so instrumental in helping me navigate my dad's estate, which was contested because, God rest my dad's soul, but he was, he had a few ex-wives and some estranged children. So, it was a neat and fun, and yes, I use that sarcastically, estate to settle, I'm sure. But, it was the way you helped educate me and walk me through it, has helped me be a better realtor for other people who have had to go through the same thing. So it's so worth it to have you in their corner to help navigate this whole process. We do have a question. If two parents die with minor children, the child gets everything?
Yes.
Yes. That's what he said. He said yes.
Yes.
Now, unless you said in your will that you didn't want them to get everything. And the other thing we talked about, this goes back to my trust question. If you had both parents die and you have a minor child, is it better to put it in a trust then, and then have a, and you'll have to, a person who manages the trust for the minor child?
All right, so I assumed the question was, if two parents die and they have a minor child and they don't have a will, does the minor child receive the assets? And that's why I said yes.
Okay.
So if you have that situation and the minor child receives the assets because there's no will, the minor child gets the assets when they turn 21. I think that's way too young for a person to receive an inheritance of any significance. If you have a will, you can create a trust for your children so that they don't get the money with unrestricted use of the money until they reach later ages. And the whole time the money's in trust for the children, it can be used to pay for their education, for their medical, for anything really. But it's just not that, it's not that they have unrestricted access to the money. They can't take the money out and throw a party for themselves or buy a $80,000 car when they want.
Got it. Okay. Well, I'm going to go back here to Jack's information and share this again one more time for any viewers that are live, or this will be posted on my YouTube and a few other places so that people can refer back to it. It was hugely helpful. Jack, do you have any final words other than, if you don't have a will or these three things, please get them right away?
No, everybody be safe out there, and I appreciate you having me on for this. Nice doing this together.
Absolutely, Jack. It was really good and such good information for everybody. And you probably didn't catch the subtle hint, but Jack and I have
I wasn't going to out you.
Tried to do my will for a long time, and we just haven't finished the last the second thing. But we'll do it, I promise, because we need to. So, all right, Jack. Thank you very much. I'm sure I'll see you in the neighborhood, and take care.
Thanks, Alicia.
See ya.
Bye.